Welcome to AT&T's teleconference service. Please. There are 1 participants on the call, including to request a special. To place all participants in broadcast mode, press 1. All participants are now in listen-only mode.
Good morning, everybody. I know we're still a few minutes before 10 o'clock. I just wanted to let everybody know Commissioner Cardenas, unfortunately, has had some travel delays. And so we're going to postpone the beginning of the meeting until 10:15 to give him a few extra minutes to be here on time. So we will call the meeting to order at 10:15. All right, good morning, everybody. We're going to go ahead and call the meeting to order now.
Commissioner Cardenas?
Here.
Commissioner Hatch?
Here.
Commissioner Hayward? Here. Chair Matich?
Here. Good morning, everybody. Before we begin today, I wanted to take a moment to talk about the public comment for items not on the agenda. Taking a step back for members of the public, the FPPC exercises two distinct functions as a state agency. Sometimes when we enact rules or regulations, we sit as what's known as a quasi-legislative body. In that context, we welcome all public comment, and commissioners themselves, for that matter, conduct additional research themselves, talk to folks, et cetera. That is appropriate in a quasi-legislative setting. However, we also sit at times as judges, essentially, in a quasi-judicial setting. Today, with respect to item 20, that is the commission's function. We have an item that has gone through the enforcement process. It's been weighed in on and decided by an administrative law judge. And our job is to accept, reject, or modify that decision. The rules of public participation are different for item 20 because we are sitting essentially as judges. And as commissioners, we are bound by a similar code of judicial ethics when we consider that matter. As a result, with respect to item 20, we will accept public comment under item number 1 on general enforcement principles. We will not be accepting public comment on the specifics of item 20. And that is so that we can properly exercise our functions as a quasi-judicial body, which includes not considering material that was not presented to the administrative law judge. Put differently, our decision on item 20 is confined to the record that was developed before the administrative law judge. To the extent we have received public comment on item 20, we will only consider it for general propositions. We will not consider any specific information regarding Ms. Shelley's case. With that, I wanted to open public comment for items not on the agenda. Good morning.
California. I'm here to reiterate a letter that had been previously sent to you by Scott Vaughn in October. And I'll just start. In 2010, Supervisor Kirk Euler from Placer County requested that all management salaries be reviewed by the Board of Supervisors. This was hailed as a great step forward toward transparency. In this year, the summer of this year, he personally violated that transparency with a clear intent to hide his wife's 28% increase in salary. Next year, with 20 years of service, she'll retire and will have added about $1,800 a month to her salary going forward to the retirement benefits, which if you take 25 years, it's about $500,000. It's over $500,000. The FPPC has a 4-step process to determine a disqualification to vote. One, does the government decision have any financial effect on any of the public officials' financial interests? Clearly, there was in this case. Will it be a material effect? $500,000 in retirement? It's a pretty material effect. Is there a difference between what other people got for raises and what Commissioner Euler's wife got for a raise? Well, the average raise was 3%, and hers was 28%. That is what I would call material. So you guys take that and say, well, if any one of these, or all three of them in this case, apply, then maybe it should be basically investigated. And it looks like there would be a conflict of interest. So Commissioner Euler did not he said, I'm not qualified to vote on this. He should have abstained. And there's rules about how you have that occur. And if he needed to announce that and step out of the meeting, having announced the fact what was going on and what was at stake here. He did not do that. That lent the proceedings to become secretive. Nobody in the public was informed of the raise that his wife would get, and as a result, it was never discussed in public forum, as you are bound to uphold throughout the state and make sure that people had open and transparent government decisions. I guess even more alarming, the fact that he did that personally, was the number of individuals who acted in complicity and conspired with him to withhold this information. Meetings went right on. There was many individuals on the board and the county council and others who were there to make sure that didn't happen, and they looked the other way and said, so what? It would appear that this is systematic corruption, and it would appear that you guys would be concerned about that.
Sorry, I want to hear you conclude your comments.
That's it. That's fine. And well, that was basically it. So as guardians of the public trust, we're looking to you guys to make sure that this is looked into, because it appears to have been violated. Thank you. Thank you.
Question of the presenter.
We normally don't question public comments
It's okay to do so.
briefly.
Sir, I had a question.
Sure.
I recall receiving materials at the previous meeting that you're referring to, and I don't want to assume anything, but you did, as I recall, file a complaint with the commission,
Correct. Mm-hmm. We did.
and so
And
that's the process that you should follow.
we are following that. I think there was, the comments came back and said, we didn't have, what was the quote on it?
I'll address that in my public comment.
Okay.
Okay.
Oh, thank you. Thank you.
Okay, just not to pass the buck here, but CalPERS has, very specific laws. I had something to do with passing them that allows them to undo pension spiking that has occurred in the past. And if you haven't followed that avenue, you should.
Yes, we will. But we're looking to, if we hadn't learned about this in other ways, it would have gone unchecked. And we don't want another Bell, California in our backyard.
I understand. Thank you, Mr. Chairman.
So I will just answer those really quick. I know I have 3 minutes. I'll work on it. I have submitted something to CalPERS for a formal complaint, because I do believe this is pension spiking, and they are investigating. We do have a sworn complaint, and so I'll address some of those things now. I think in its most recent response, the FPPC enforcement decision noted that insufficient evidence of a violation of the act, they had insufficient evidence to pursue an enforcement action. I'm not sure what evidence we need. We've provided you all the documentation, the video. The Fair Political Practice Act says a public official who holds an office specified, who has a financial interest in a decision, shall, not could, maybe if they want to, upon identifying a conflict of interest or potential conflict of interest, and immediately prior, do all of the following: publicly identify the financial interest that gives rise to a conflict of interest or potential conflict of interest in detail sufficient to be understood by the public. I like to consider myself the public, because I'm just an engineer, I'm a father, I have a family in the neighborhood, I pay my taxes, and I expect transparency. You know, the commission was formed in '74, I read, after Watergate, and the Californians passed Prop 9 for open and honest transparency in government. And so we're looking for the FPPC to take all the information. I've filed Public Record Act requests. I've gone to CalPERS to eliminate loopholes that seem to be in place, or maybe they're not loopholes, but to find what evidence is required when someone doesn't do something that they shall do. An absence of evidence is the evidence that there was no document, no statement. There's nothing there to show this was disclosed. The statement is in detail sufficient to be understood by the public. I found out about this because I have other issues with Placer County, and I'm quite vocal about it, through a whistleblower, an anonymous letter that came to me in the mail to my home, I don't know from who, I assume from inside Placer County, that detailed all of this. I would never have found it. Never, because it wasn't put in sufficient detail. It wasn't in the ordinance. It wasn't discussed at all. If that's not hiding stuff, I don't know what is. So I just wanted to address that fact. I have provided, and I've done a lot of work, and I know that your staff is going to look at. I've done the sworn statement. I've done the appeal now to the executive director. I provided that to the commissioners, and I just wanted to say that if this isn't enough factual evidence, what is? Because it says clearly in the Political Reform Act, you shall do something. It wasn't done. Thank you.
Thank you. Is there additional public comment on items not on the agenda? I think Commissioner Hatch has a comment that he'd like to make.
There's an additional item on one not relating to the previous speaker's concerns. And this was an email from Michelle Baker that I'm referring to. I just want to say in answer to her email that I too am concerned about the misleading article that Michelle Baker referred to in her email. We have both been victims of unsubstantiated rumors put forth as though they were factual evidence of misdeeds. Ms. Baker was misled by the inflammatory article, and my integrity has wrongfully been impugned. For the record, I have not allowed anyone to discuss this or any other enforcement case with me outside of a public commission meeting. I've always recused myself in any case where a person accused of a violation of the PRA by Enforcement Division has been known to me. However, the time for recusal is not until the enforcement case comes before the commission itself for adjudication. At that time, I will surely recuse myself from participating in the deliberations and vote. That's all I wanted to say. Thank you.
Thank you, Commissioner Hatch. At this time, hearing no further public comment on items not on the agenda, I'm going to take item 20 first today. So with respect to item 20, as I alluded to at the outset of the hearing, we are sitting as a quasi-judicial body, essentially judges, when we evaluate item 20. We're going to accept at this time arguments from both the respondents and the complainants. Each side will have 5 minutes total, and they may reserve up to 2 minutes for rebuttal. Do we know whether Ms. Shelley is here and intends to present argument? Ms. Shelley? No, the enforcement staff will begin. You'll go after that. Would you like to reserve any rebuttal time? 1 minute of rebuttal. All right. Ms. Linker, will you keep track of the time? All right. Chief of Enforcement West, would you like to introduce your team?
Certainly, I have with me Teresa Gilbertson, enforcement attorney who has handled this case and will be making the presentation today.
All right. Welcome, Counsel Gilbertson.
Good morning. Thank you. My name is Teresa Gilbertson. I'm here to present case 15003. It is Susan G. Shelley, Susan Shelley for Assembly 2013, and Susan Shelley for Assembly 2014.
Do you intend to reserve any rebuttal time?
Yes, just a minute.
Just 1 minute?
Yes.
Okay, so we have 4 minutes.
This case came before us pursuant to a mandatory audit that was conducted by the Franchise Tax Board in connection with Ms. Shelley's candidacy for the special election held for the 45th Assembly District in 2013. This case was heard by the administrative law judge on June 19th of this year, and we're here today to ask the Commission to adopt the proposed decision. This decision accurately applies the law and states factual findings that are supported by the evidence that was presented. The findings of that proposed decision are that Ms. Shelley and her 2013 committee failed to timely file 3 pre-election statements in connection with those special elections, and that her 2014 committee failed to timely file 2 pre-election statements. The finding concluded that $2,500 was the appropriate penalty for violating Section 84-200.5. This mid-range penalty balances the serious public harm that occurred with the mitigating factors that were presented. In mitigation, Ms. Shelley was a first-time California candidate, having previously run for federal office. She maintained 2 open controlled committees during a special election, and she did consult the Technical Assistance Division for assistance during that election. However, the violations here are serious. She ran a $100,000 committee between her 2 committees, and she failed to disclose this significant activity for each and every pre-election for this special, primary, and general. Pre-election statements are basic and fundamental part of our disclosure process. They're not trivial nor meaningless paperwork, but they are the primary vehicle for transparency. In further aggravation, she failed to timely file a pre-election statement and didn't file it until after the election. The administrative law judge in this case she took notice of several decisions that this commission had approved of. She considered the range between $2,000 and $2,500 for this particular violation, taking from similar facts and circumstances, and she settled on a mid-range penalty for each count. In conclusion, we recommend that the commission make the technical and clarifying changes that we recommended in our first brief and adopt this proposed decision as the decision. Thank you.
That mid-range was what, 22.5?
It was $2,500.
Yeah, 2,500, thank you.
Yeah.
Those per fence.
Yes, per count.
Working, push the button. There we go. Okay. Well, I'd like to begin by stating that I agree with you that this is fundamentally important, that there is disclosure. I attempted to find out what all the requirements were. I was on the Secretary of State's website. That's where I thought they were. That's where the Form 700s were. That's where the Statement of Intention was. That's where the Statement of Organization was. I was on the county site. That's where they gave me the stack of papers. They gave me notifications of everything down to the day that they pulled the letters for the ballot order. Nowhere in that material, and I looked through it, was there a schedule for pre-election reports. Now, because I had been a federal candidate, I knew that there would be one. There was one in the federal race. They send email notifications of when they are. And this was a special election. So it was not as if there were other candidates who were sending me emails, oh, there's a deadline. I did not know when it was. I called and I emailed the commission to find out when it was, because in looking around, I saw that someone else had filed something and I had missed it. In looking for it, I believe it was August 18th or 19th, it's in the material, when I looked. And I emailed, I said, I missed it, I'm sorry, I'm on it, and I had a question about the 2 committees. The reason there were 2 committees is because the incumbent ran for 2 offices and did not resign from the assembly when he won the second one. So there was a long period between March and June, really earlier if you expected that he would win. There was a long period when it was not legal to raise money any other way for the special election, which was necessary in a competitive race. There was no legal way to raise money except to open a 2014 committee. And I was a first-time state candidate, had no idea how complicated the rules were. Didn't know about all the different kinds of reports. I knew about 24-hour reports. I knew about semi-annual reports. I knew about anything that was on the Secretary of State's website. I looked for information. I emailed. I asked. They never sent me a filing schedule, not a link to a filing schedule. They answered my questions narrowly. I said I was a first-time candidate. I said I was acting as my own treasurer. Every time I saw that I had missed something, I filed it. That's why they were late, because I was checking what other people had filed, looking for the dates. I never found them on the FPPC site. I thought everything was on the Secretary of State site or the county site. I filed everything I knew to file. And at the end of the campaign, knowing how chaotic and busy it had been, I sent an email saying, I want to make sure everything's in order. Is anything missing? Is anything incorrect? I never got an answer to that. I was first notified that I had missed a pre-election report when I got fines from the Secretary of State, which had totaled all the way up to where I had filed my semi-annual report, which I thought was the next one due. And I wrote to them and I explained the situation, the two committees, the complicated filing, the fact that I had looked for the information. They waived liability for much of it, for good cause. And in January of 2016, I got a letter saying, send us $6,000 and sign this and waive all your rights or we'll come after you for worse. And then they did. And this has been an extremely abusive process. To defend yourself against the state of California as a first-time newbie candidate is a very significant challenge. But I felt that the public should see this, not for me, but for all first-time candidates. And this commission has made changes in acknowledgement of how difficult it was. You've made an online toolkit. You've changed some of the fines to warning letters. You've made changes. And yet this proceeded as if it was the worst thing in the world. I tried to comply. And there is no oversight of the intake, no oversight of the investigation, no oversight of the judgments they make, no oversight of the settlement talks. And then you can make an adjudicated decision here based only on what went into that record. There's no oversight. Thank you.
We're sympathetic to the complexity and some of the difficulties around the requirements for filing. However, the difference here would be the size of this committee and the repeated nature of the violations. There are certain thresholds built into the act that protect candidates, such as to even be audited by the Franchise Tax Board, you have to have raised or spent $15,000. In addition, the size of this committee, the amount of disclosure that did not happen prior to the election is serious, and we took into consideration and dropped several counts and presented those 5 before you today. And the oversight of our decisions are that the commission themselves approves them each month. Thank you.
1 minute for rebuttal. First of all, with regard to the $100,000, there is no one in politics who thinks that is a lot for a combined primary and general election in an assembly race in a district that has 250,000 voters. That won't buy a first-class stamp. The committee was significantly outraised by all of its opponents in the primary and by its general election opponent. I filed 24-hour reports accounting for 78% of the money that was donated during that period of the missed report. 78% of it was disclosed prior. The money that was raised in the 2014 committee before the 2013 election was called was all disclosed by July 31st for September 17th primary. It was all disclosed on 460s for the 2014 committee, which stopped raising money when the 2013 committee opened. The fundraising is split over the two committees because that's what I was told was legally required. I think there is a tremendous chilling effect here. To find a first-time candidate who is acknowledged to have exercised good faith for reports that were all due within a 90-day period with no notification of the filing schedule or that they had been missed. Thank you very much.
Yes, if that's what the desire of the commission is.
Modify the administrative law judge's decision in some ways, or we can reject that decision and hear the matter anew ourselves. And so those are the 3 options before the commission and what we'll be considering and discussing in closed session at this point. Thank you. We'll adjourn to closed session. All right, we're going to go ahead and call the meeting back to order after a closed session. The commissioners met in closed session. We've given some direction to staff, and we've recessed our closed session at this point. We intend to reconvene in closed session again at the end to conclude our deliberation on item 20. So at this point, while that's happening, we're going to go ahead and move on the public agenda. So we're on to item number 2, approval of the September 2019 commission hearing meeting minutes. Do any commissioners have comments or edits to those meeting minutes?
No.
All right. Any public comment on the meeting minutes? Seeing none, do I have a motion?
Move approval of the minutes.
Second.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye.
Chair Matich?
Aye.
The motion passes.
Moving to the enforcement consent calendar, that's items 3 through 9. Do any commissioners have an enforcement consent calendar item that they wish to pull from consent? Seeing none. Do we have any public comment on the consent calendar? Seeing none. Do I have a motion?
Move approval.
Second.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye.
Chair Matich?
Aye.
The motion passes.
Moving to item 10, this is notification of our intent to pursue a default decision in order at the November commission meeting. There's no formal action to be taken on this item.
If I could, Mr. Chairman, could I ask Ms. West to tell us whether she's had any further contact with this person?
No, we have not.
Okay, thank you.
Right. Moving to item 11, Executive Director Jones and Commission Counsel Cornwall. This is the updated rules for public participation at commission meetings. Executive Director Jones, do you want to lead this discussion?
Thank you, Mr. Chair. At the Commission's previous meeting in September, the Commission adopted a slate of rules regarding public participation. I hope the Commission was delighted to see those posted on the wall and available out to the public participants out in the hallway today. But in addition to that, Commissioner Hatch raised the thought of having limitations on what type of audiovisual equipment could be used by public participants. And you may remember that there was a colloquy that went back and forth where issues of possible ADA issues and how, the functional issues of how it would fit in the room came up. We asked for opportunity to go look into those. We have. What you see before you is a response to hopefully that honors the intent of Commissioner Hatch's proposal, but does give some legal clarity with respect to this issue.
A little verbose, but it's certainly acceptable.
Do any commissioners have any questions about the proposed amendment to our public participation rules in item 12? Is there any public comment on this item? Hearing none, do we have a motion?
Move to adopt.
Second.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Chair Matich?
Yes.
The motion passes.
Thank you very much. Moving on to item 12. This is our pre-notice discussion of amendments to Regulation 18702.4. And discussion will be led by our General Counsel, Mr. Bainbridge, and Assistant General Counsel Lau, and Legal Division Counsel, Mr. Cornwall.
Good morning, Chair, Commissioners. We are presenting today for pre-notice discussion the amendment of Regulation 18702.4 pertaining to the amendment of the materiality standard for sources of gifts. This is one of the final steps in amending each of the materiality standards to provide bright line rules. The only real change that this particular standard would involve is tying it to the recently amended standard for the materiality for sources of income that are nonprofit organizations. By tying it together, it would ensure that these standards are reflective and harmonized with one another, And this is also in line with essentially how the regulation was worded prior to amendment in 2015. So if there are any questions.
Do any commissioners have questions on this item? Have we received any input or feedback from either the regulated community or the public in general about this item?
I haven't, and I'm not aware of any. Yeah.
Okay.
Is this going to be scheduled for interested parties?
It's not currently set for one.
Okay.
Is there any public comment on item 12? Seeing none. Thank you very much. We'll return to this in another, 2 months. Thanks. All right, moving on then to item number 13. This is our pre-notice discussion of amendments to regulation 18702.5. Again, we have General Counsel Bainbridge, and we have Commission Counsel Christie. Welcome to the table.
Good morning, Chair and Commissioners. Matthew Christie here on behalf of the Legal Division, here to present the proposed update of Regulation 18702.5 for pre-notice discussion. The Political Reform Act's conflict of interest provisions prohibit a public official from taking part in a governmental decision if it is reasonably foreseeable that the decision would have a material financial effect on one or more of the official's financial interests, including an official's interest in his or her personal finances or those of immediate family. The Commission has recently undertaken the update of its conflict of interest regulations to improve their clarity and guidance through the incorporation of bright-line objective materiality standards. As my colleague Kevin pointed up, we're winding down this update process, and Regulation 18702.5 is the final regulation setting forth materiality standards that we'll be considering today. Staff proposes updating Regulation 18702.5's materiality standard applicable to officials' personal finances. And the main change that we'd like to see undertaken is getting rid of the existing materiality standard, which is met when there is a measurable financial benefit or loss from the decision. We found that this subjective standard has been difficult to apply in some circumstances, and so we're suggesting returning to an objective bright line standard, this time of $500 as a threshold. We also make other changes to the regulation in order to improve its clarity and guidance, and I'd be happy to answer any questions the commissioners have about those changes.
I have one question, more of a generic nature. This is a continuation of the commission's work to create objective standards that are easier for the regulated community to follow, easier for us to administer in some ways. Since we've begun that process, has the legal division seen, I guess, what's your experience been, is really my question. Is it easier to provide advice? Are you getting fewer or more advice requests? What's your experience been?
I think definitely as far as getting to the advice, we're still sorting out the new regulations and making sure that we have a grasp of all the different ways they might be applied in the different circumstances. But so far, I think everything's gone very well, and we're happy with how they've performed in action.
All right. Have you received any feedback from the regulated community or the public in general about sort of the pros and cons of moving to this more objective approach in our regs?
I think we have seen some reluctance with respect to change, but in general, I think people are appreciative of the objective standards and are happy to see us undertaking these changes.
Okay. I've heard some positive feedback that it's now easier for them to apply. I haven't looked to see if the numbers of requests have gone down from prior years, but everything I've heard, everything people have said to me has been positive about the way it's being applied. It's still pretty early in the process, but so far, so good.
All right. I spoke at the League of Cities conference yesterday. I had a number of local officials, I think, indicate that they were pleased with the approach. It was easier for folks to understand when there was a conflict, and the city attorneys, I think, have appreciated that, so it sounds consistent. Do other commissioners have comments on this? All right. Is there any public comment on item 13? Seeing none, thank you very much.
Thank you.
I'll just add on both of those regulations to remind people who may have thoughts and would like to add from the public, they will be up for consideration for adoption in December. So to the extent you have comments that you would like to communicate to us, either in writing or you want to reach out to one of the attorneys assigned, please do so as soon as possible, especially with the holidays coming up.
Is there a particular deadline you'd like those to be received by, like in November?
Yeah, mid-November would be good. We could say November 15th. The agenda for December will be the first week in December, so by then it's pretty well cooked. So the earlier the better, but definitely by November 15th, I think, is the arbitrary but meaningful deadline we can set.
Thank you. Arbitrary but meaningful. I'm going to cogitate on that for a second.
It's like not arbitrary and capricious, it's not.
Item 14, this is an update on the Digital Transparency Task Force that we approved creating at the last meeting. And the update is we don't really have an update at this point. Hopefully we'll have a better update in November. So we're continuing certainly to focus on this. Item 15, Commissioner Manual Review Update. General Counsel Bainbridge, Senior Counsel Fesser, and Legal Division Counsel Mr. Cornwall. This is coming back to us, and what is coming back to us is the commission had asked for staff to identify clearly for us what provisions in chapters 3 and 4 of our policy manual are legally required, what are perhaps best practices, but not strictly speaking legally required, and then other, I guess the third bucket would be narrative statements or things that don't have legal significance necessarily. And so staff has done that. I think the color coding has been very helpful at least for me to follow. So that's what's before us, and this is an opportunity for commissioners to ask any questions about that.
If I could, on the color coding, I found it helpful that it was done this way. I would say, though, that I saw a number of areas where green material would probably more apropos to be the orange color. Particularly, what was it, whenever I saw a sentence start with thus, it usually, what followed was probably should have been orange, in some cases was, but, and just as a petty little complaint or suggestion, I think that all the citations should be hyperlinked in the final document when we get to that part, before I forget it. And some of the items refer to either go to a website or this or that, and I would prefer that we could, as we progress, that maybe those could be included as hyperlinks as well. And I'll just leave it at that for now.
In response to that, what we found in doing this exercise is that both of these documents, especially the Chapter 3, we think could use significant reworking and reorganization to make it much more clear and provide the exact, what the law is, the actual language, and then clearly delineate when we're talking about best practices.
That would be really
So that's our intent moving forward is to separate those two out, make it much more clear what's what. The plan, as I understand it, and obviously we can change that plan, is for us to come back with suggestions of best practices, potential best practices that we're going to work with Commissioner Cardenas on, probably in the form of a memo that we would bring back to the commission. And then the commission can have a discussion of what those best practices would be. Once we have concrete ideas on what sort of best practices we want to implement, then we'll go back and draft a code of conduct or whatever we want to call it.
Thank you. Mr. Chair, I had just a couple other suggestions that are just general in nature. Under the limitation, the ban on gifts, the paragraph following that is limitations on gifts, and it refers back to the ban on gifts as a restriction, I think, is on gifts. I somehow left took the word out, but it should refer back to it being a ban on gifts instead of a restriction on gifts. So that for the uninitiated, this is like your first impression, as a new commissioner, and it seems like you're referring to something else altogether that's not there. And I struggled with this when I was first reading this book myself.
So use terms consistently.
Yeah, consistency in terms, yeah.
Okay.
And then a number of places, I thought there should have been some citations where they were talking about regulation or statute. And these can all be picked up, but it would be helpful to, as you go along, trying to figure out, pick those kinds of things up. And H, ex parte communications, there was a reference to pending opinion. I'm pretty sure that the intent there is pending commission opinion, and it should say so. Because it could easily be, mixed up with just us, like an advice kind of thing. Again, a number of notes about lack of citations, where they're referring to a reg or a statute, there should be a citation of the section number. Thank you.
Casca, a question to follow up on that, because I think that's a really good idea, actually, having the links to the citations. Do we put this manual up on our website currently? Is the most current version up there?
I don't believe it is, other than being on the agenda. So technically it is on our website. Prior to this becoming an issue that the commission was considering, do you remember? I don't think it was on the website.
Well, this is something for us to decide later on, but for my own part, this sort of made me think that we may want to have this on the website so the public understands very clearly what the transparency rules are that we follow ourselves, and having the hyperlinks that Commissioner Hatch mentioned would just facilitate the public's understanding of that even more. So I think that's a good idea.
I agree, and historically it's been given out to press anyway, where there are requests for understanding about what the rules are. So certainly it'd be more equal if it was on the website, let's say, in terms of people who don't know any better than to make a public records request.
Do you have other commissioner comments on this?
Yes, Mr. Chair. I had and have had in the past, as you'll recall, a number of thoughts about to what degree we want to have reporting requirements on ex parte communications that are outside of the adjudicatory context, and so actually aren't really ex parte, but more like just talking to the community and whatnot. But I'm going to hold off on a bunch of those just because I want to sort of see what your draft looks like. But just suffice it to say that if it's the consensus of the commission that we do have some kind of reporting, I think the devil's going to be in the details, and I just want to make sure that we come up with a standard that people follow and can follow and is workable. So that's the only thing I'm going to say about that. Then as far as substantive things to maybe include, and this I'm bringing up because I'm perhaps one of the worst offenders on this little standard I would like to reform, which is the use of text and email while you are on the dais. It looks horrible because it looks like we're doing secret things while people are talking to us, while I have to tell you that most of the time it's me responding to my kids. But my kids can wait. But I'm an offender on that, and I would like to propose a policy that prohibits the use of text, email, or other electronic communications, including Snapchat and messaging and whatever, while we're on the dais. I think I can exercise the discipline to put my phone away when I'm sitting up here. That's the least I should be able to do, and I feel like that would be a good move for everyone. And this is another thought that I want to share, not necessarily that I'm going to insist that it's a great idea, but since we've had the experience recently of thoughtful and complicated comments coming to us about regulation the day before we're voting on the regulation. Does it make sense to close public comment 48 hours before the commission meeting? I only offer this because I know lawyers often wait until the last minute to file things because the incentives are for you to do that. And so maybe if we moved up the last minute a day or two, everyone would be happier. People would prepare their comments knowing that we would have the time to look at them. We would have the time to look at them. People who read them and go, I'm not sure that's right, at least are on notice that they can come to the meeting and maybe talk about what they feel is not correct about the comments that have been filed. And so that's just another thing I thought could be incorporated into this. Otherwise, good luck, and I look forward to your memo.
Commissioner Cardenas, did you have any comments?
I appreciate staff's work that's been done up to this point, and I look forward to working very closely with Dave and the rest of the staff. I do have some concern about a public comment limitation, but we will thoroughly investigate that and bring our best recommendation back.
Commissioner Hatch.
Yeah, thank you. Mr. Chairman, while I'm at it, in the ex parte communications section, on page 17, I think it's of the draft that we've received. It articulates two alternative views with reference to the non-litigation parts of our jobs. And they cite a Lackner case, 1976, for one school of thought, and then another one, Yamaha versus Board of Equalization, 1998, for a different view of how things are, without really telling this uninitiated reader which is the more traveled path or the appropriate path between them. It just sort of lays the two out. One is much more restrictive than the other in terms of conduct. But then I'd also notice another citation further down, Brown versus FPPC 2000, wherein it cited Yamaha, which was the other path of the two. So I'd kind of like to know, when we get to this part about how you suggest the new draft, how these interrelate and which is the more beaten path that we should be following in any suggestions that we make.
Okay. Yeah, our memo will explain sort of the.
Thank you.
So just so I'm clear, I think I hear what you're saying is, we have we cite two different cases in here, which offer different perspectives on a particular best practice. Part of your memo, the purpose of your memo is going to be identifying with Commissioner Cardenas these options for us and the correct case citations. And of course, we'll pick which, if any, option we want to impose on ourselves, and then just make sure that the case citations match that appropriately and don't include things that we haven't specifically decided to impose on ourselves, I think is what we're trying to do.
Yeah, well, we lay out two different courses here, and we don't make a judgment as to which is the right one, but yet someone who would read this on the website say, well, it should be this one, the one I like versus the one I don't like, in terms of the context of whatever they're seeking. But I didn't have time to pull up the cases to take a look at them, but I'm guessing from the citation of the Brown case that probably the Yamaha case is more the direction we should be going, but nonetheless, I would like them to talk about it and figure it out.
Yeah, on those specific cases, I think they're tangentially related to this issue at best, so you may not even see them again. But we will lay out the different legal sides and legal considerations, and so you'll have all that information.
Thank you.
Is there any public comment on item 15? All right, seeing none, we'll proceed then to item 16. These are the committee updates. One thing I wanted to mention before we get to the updates themselves is we've recently made the audio files from the all committee meetings available on our website so that the public can track and be involved with what goes on in our standing committees as well.
I had no idea. I'll have to be a little,
I think
less
that's
funny.
very positive. I think that's very positive. Thank you.
All right, who wants to go first? Budget?
My updates in the agenda, I'm going to just submit it as written.
Thank you. Commissioner Hatch?
I lost my piece of paper. The dog ate it. We reviewed a proposed regulation that dealt with how you would describe sponsored committees to try and be more clear as to what is appropriate and what's not. We had some input, and in reviewing it, we thought perhaps the staff could get a chance to, because we were pretty up against the deadline. So we suggested that we give time for that to gel, and then delay consideration until next month. So that gives us an opportunity to figure this out in a way that serves everyone. And at the appropriate time, when legal is revised or not their draft, then we would hold another committee hearing to give anyone who has concerns about this to air them then, so that they'll have some opportunity to hear that and see whether or not they want to incorporate it to yet another draft before we actually take it to, for approval by the full commission.
Mr. Bainbridge, do you have something to add?
I would just piggyback on that to say we had an informed persons meeting. I think it was last week.
Oh,
it might have been. Yeah, I think it was last week. They start to run together, and received additional input that we're also considering. So
okay,
we're working on it. It's a tricky puzzle, but once we have something we feel good about, we'll bring back to the Law and Policy Committee.
Great, thank you.
And of course, the other item that Law and Policy will be considering in the near future is the unregistered lobbyist issue, which will be an ongoing project.
Yes,
I imagine.
Mr. Senior Moment adjourned the meeting before the chair could call to his attention that that was the next item on the agenda, so we didn't consider that. And again, I apologize.
All right. Any public comment on the committee updates? Seeing none. We'll proceed to the next item, item 17, our legislation update. Mr. Ung, welcome to the table. We should begin by saying congratulations.
Thank you.
Mr. Ung and his wife recently had a child, so congratulations.
She did all the hard work, trust me. Yeah. I'm here. I don't know if I'm sleeping all that well, but I'm here. But thank you, commissioners. My update today is going to be based on the October 15th updated legislation report for the commission and the folks watching at home. Since that update was released after the governor had concluded his legislative actions on October 13th. As it states in the update, the governor signed all 11 Political Reform Act bills that were presented to him this year. He vetoed none. And the only other thing that I want to highlight in the report is that 2 bills have delayed operation dates. That's AB 571, which will begin in operation January 1st of 2021, and AB 909, which is our sponsored legislation dealing with treasurers, and that is operative upon certification of a new Cal Access system that's being designed by the Secretary of State's office. Other than that, the report is as submitted. I just want to thank the commission for being committed to a proactive legislative agenda. I think we had a very successful legislative session in regards to our sponsored legislation and legislation that we had supported. So thank you for sticking to the process and trusting staff and the team that we have here and working through all of the amendments that came through and the timing and all of the committee hearings that take place. That being said, staff has also initiated our legislative development process to present some recommendations to you, I believe, in December. And so look out for that coming up. Happy to answer any questions.
Any questions?
What do you think is possible we can figure out a place on our website that we could put those delayed date cautions up for folks that would be expecting these things to otherwise go into law in January?
I can definitely work with staff, legal division, education to make sure that it's communicated to the public. We are trying to find ways to, well, right now it's mentioned in the larger printed act in the appendix, but that's if you look in Appendix 5, that you will see that there are a number of, it's not just these two, there's at least one other piece of legislation that's been operational upon certification of Cal Access. And so I think I can work with Education and Legal Division to put that someplace prominent. We definitely do our best to mention that in any new law presentation that we make to all of the interested stakeholders, but point well taken.
And also congratulations on a great year.
Thank you. A team effort.
I tend to agree with Commissioner Hatch. I think it's a really great idea. If it is possible for us on our website to, after bills are signed at the conclusion of a legislative session, have some news alert that folks, members of the public, can quickly and easily go and understand what new rules have just been adopted, in addition to the efforts I know education and the other folks are already doing.
I believe we have a new law page on our website. I'll look again, and if that's the case, then we'll make sure that we put those documents all in one place and see if we can feature that more prominently on the homepage. I think you have to dig a little bit to find the new law page, which isn't all that helpful.
That was going to be my point, so I think that's great. Any additional commissioner comments?
Just a couple. Since AB 864 was signed, this brings to rest the whole 5% question for printed advertisements larger than, 5% per line or 5% per disclosure.
I would like to say it resolves the issue for my department legislatively, whether or not legal will continue getting questions about the size of disclaimers on large print ads. I'll leave that to Dave. Yeah.
Fair enough, but at least we got what the author thought the author's standard was, but didn't really read that way. We got that clarified.
That's correct.
Okay, I mean, that's my gloss on it anyway. And then of the things that were signed, is there any sort of, I don't know, budget implications? Did we get legislation signed that had fiscal impact kind of language in it that might change budget issues, to the extent you can say?
The only bill that we had keyed that had significant fiscal effect on the commission was Assembly Bill 571, which deals with default local contribution limits. And any of those questions I can hand over to Mr. Jones or Ms. Hahn to answer. The bill is delayed until January 1st, 2021. And I'll leave it to Ms. Hahn to discuss how that BCP process works when a bill is delayed out that far.
Would you like more information on that?
No, I was just trying to remember. I knew there was one that we had a fiscal impact on, and now that clarifies exactly what I needed. Thank
you. We also had a bill that we had a big number on, but that one was made a 2-year bill, correct?
There were a few bills that had big fiscals that are 2-year bills. I think the one that you may be discussing is Assembly Bill 1217, which deals with issue and electioneering ads, and that is a 2-year bill. And we are waiting for the author to convene a stakeholder meeting to discuss amendments for 2020.
Right, and that had a significant fiscal impact if it were to become law, as I recall.
Yes, a little north of $1 million, yeah.
Yeah, thank you.
Additional questions for Mr. Ong? Hearing none, is there any public comment on this item? Seeing and hearing none, thank you very much. All right, we'll move on to item 18 then at this time. This is our advice letter report. Commission General Counsel Mr. Bainbridge and Assistant General Counsel Lau. Anything you would like to bring our attention to in the advice reports from October?
Just here to answer questions. If anybody has any comments or thoughts or suggestions for the advice letters issued since last month.
All right. Do we have commissioner comments? Commissioner Hayward?
Mr. Chair, I'd like to talk about A19142, which was the letter that we issued to Hicks regarding an academic scholarship to the requester's daughter from Cal State University, Dominguez Hills. In general, I mean, we talk about how it's not a gift if it's reported as income. Okay. The scholarship's not a gift to the extent it was earned by your daughter. Okay, and I just want to sort of back off this a little bit to talk a bit about merit aid in general. Unlike a scholarship that you would get from, say, the Daughters of American Revolution or the National Resources Defense Council or something like that, where they cut you a check, which is money, which is fungible, sometimes it goes to the school, but sometimes it can go to you. Merit aid or need-based aid is usually taken off the total of the tuition that you pay. And so you don't get money that you could use for some other purpose. You have to use it for tuition, you have to use it for books, and if it's used for those purposes, it's not taxable as income. And I guess what is bothering me about our approach here is we are talking about treating something as income that people who get this are probably not going to know that we think that. For example, I would not have thought that my daughter's merit aid could be considered income because I know for tax purposes it isn't. It's just a discount off the advertised total price of tuition. And by the way, my daughter doesn't go to school in California, so this is not something where I'm admitting an issue, because this is now the jurisdiction question, but if she could be going to school in California, and we would get that letter each year saying, you've been approved for the president's, scholarship, and, we'll take 12 grand off of this enormous price for private school. You get my point. I feel like if we're committed to deciding that scholarships from universities, the students that are attending, which I understand to be more like discounts than cash, if that's income, a lot of people are going to be really surprised in a bad way. So I'm not sure the analysis is correct here. I'd like to know if this is a long-standing interpretation that we've applied in other situations. If it's a novel one or different in some respect, I'd like to consider perhaps withdrawing this letter and thinking about this question before we give this advice. Thank you.
Okay. I will say that I think the results would be something entirely different if we did not have a university that was entirely within the jurisdiction of the city. The question here becomes when the university that we always had a longstanding standard of when is a gift to an official's family member ever considered a gift to the official. We have a longstanding, if a scholarship is given to an official, it would generally be considered a gift. However, if it's from a bona fide competition, meaning it was a legitimately awarded scholarship, then we would have a longstanding interpretation that that would be treated as income, and that's kind of it's a way of making sure that that gift isn't subject to disqualification, unable to be accepted because it would fall underneath the gift limit exception or be prohibited because of the gift limit exception or amount. So that being the case, the question just becomes, well, is this a gift to the official or the official's child? We have a regulation that looks to what evidence is there that the source is potentially trying to influence the official. So if this was a university outside of the jurisdiction, outside of the city, we would not have reached this result. We would have just said, this is a gift intended for the official's daughter. It would not be reported by the official in any sort of capacity. But because we have a university within the confines of the city, and we anticipate that that university has a lot of mutual business with the city, we found that there was at least an indication that it could be that somebody was awarded a scholarship because of an intent to influence, worst case scenario, an intent to influence the official. So because of that evidence, we found that we applied the regulation that essentially states, because of evidence that they might be trying to influence the official, this should be considered a gift to the official. That being the case, it would still fall underneath that bona fide competition exception, which allows the official to accept the scholarship to the extent that it was awarded legitimately and not be subject to the gift prohibition of $500. That being the case, it requires that the official disclose it so that the public is aware that there is a potential that if this source of this scholarship is there on business before the city, that there at least some sort of indication to the public that this is something that could be examined further to see if there's a conflict. In most cases, it's very rare that you would be disqualified from the decision. As you see here, this is a ancillary decision that affects, what was it? It was a passport application location that might maybe implicate the university, and that's not something you'd be disqualified from, because it would any decision affecting a governmental entity kind of falls underneath a higher standard, and we would expect some sort of unique effect on the official under the conflict of interest analysis. So this is kind of a result where you get some sort of disclosure. You can kind of at least track to see if somebody is there before the official trying to influence them in their official capacity, that may be also trying to award a scholarship for that reason.
So this is what should show up on your 700.
So the official would end up having to report this as income from the university on the official 700. And if they did not do that, it would potentially be a prohibited gift under the act because it's over $500.
And I guess the distinction I want to make that I think we're losing a little bit is the distinction between the kind of scholarship you get that you compete for, which oftentimes is just a check written out to you that looks a lot like a gift or income. You have discretion over how you spend it. And the aid that comes from the school you're attending, where you don't get the cash, you don't have any discretion over how it's used, it's just pulled off over your tuition total, and thereby you don't get taxed on it, but you also don't get the discretion on how you use it. It's hard for me to conceive of that kind of merit aid as being income. It's a discount. And if it's a discount that's awarded at an arm's length, relationship, and I don't see any indication that it isn't here, I don't think it's in anything. I don't think it gives rise to a conflict. But I don't know. Maybe I'm not persuading anybody, but I think this even if this letter technically gets to the right place, because of the unique situation of Cal State Dominguez Hills being entirely within Carson, I really feel like if we, in fact, do treat merit aid as income for Form 700 purposes, a lot of people are going to be surprised by that conclusion because they don't think it's income, because it's not income for tax purposes.
I have a question. How do we treat a straight-up scholarship where a student of a public official applies for and receives a scholarship? It's a cash scholarship, $5,000. How's that treated?
I don't think, we wouldn't distinguish between this academic scholarship from the university versus an academic scholarship from a private source. If a student received a academic scholarship from a private source and receive some sort of check or amount of money, the question would be, is there any evidence that source is attempting to influence the official? We've seen cases that I've been aware of where it was the child's coach wanted to help pay for some college, and we said, that because of that nature, because of that relationship between the student and the coach, we saw that there was this social interaction, social friendship, and there was no indication that that coach was trying to influence the official. We've seen similar circumstances where it's this is just an example off the top of say the Chamber of Commerce, and they may be trying to give a financial scholarship to the student. So that might be an indication that they have business before the city council member, and we would find that as a gift it would end up being similar to this analysis, a gift to the official, an attempt to give a gift to the official, possibly a gift to the official, at which point the official needs to report it as income in order not to accept that as a gift. Because as long as it's awarded in a bona fide arm's length transaction, which is always kind of the question, is it legitimate and is it arm's length?
If I could, in the case of this university being entirely within the city, if it is reported as it is supposed to be reported on your Form 700, then it's possible to be able to see a pattern develop where everyone who's on the city council who has a college-age child ends up getting a merit scholarship from this university. It would provide that paper trail where otherwise you wouldn't even know that there was a pattern and practice of kind of favoring the council.
Yes, that would be true.
Thank you.
Commissioner Cardenas, did you have anything? Which one? I think Commissioner Hayward raises an interesting point. Perhaps staff could come back to us at a future meeting and help, I mean, at least from my perspective, help educate us and give us a few scenarios of how aid to students of public officials are treated for purposes of evaluating gifts, income, and conflicts. So one scenario, I think, is the straight up cash scholarship, what the rules are there, and what your thinking is there when you're evaluating that. Another scenario would be where you get, as Commissioner Hayward has characterized, as kind of more of a discount, a merit scholarship, and how those two approaches may be similar, how they may differ from each other, and then we can consider this a little bit more in the future. I think the first step for me, at least, is understanding the different scenarios and what rules apply in the different scenarios before we go any further.
I would point out that the definition of gift includes rebates. So I think to the extent that this is a reduction in tuition, it meets the definition of gift. So then we go into these exceptions that have been created by the commission through regulations for defining when you have a gift. I think in this case, I understand the point of Commissioner Hayward, but I think her point is more that the regulation shouldn't say what it says, not that we've interpreted the law wrong in drafting this letter, which I think is an important distinction to know where the commission's going regardless of what they do here, whether they're saying we need to withdraw this letter because we've given bad advice, or the commission saying we want to reconsider the regulation that's been previously adopted by the commission, because we think in this scenario, this isn't the result we would like to see.
Speaking for myself, I don't believe the advice letter was wrongly decided, but what I do think is, for myself at least, I would like us to have the opportunity to evaluate the regs we have in place, and maybe we start with the definition of gift, including rebate, and so the commission can decide whether that is the right way of approaching, from a regulatory standpoint, these types of student aid. So don't take the comment as a criticism of the advice letter so much as it is a point of inquiry about what our regulations provided for a particular scenario.
I'm actually okay with that. I just found the result, and I'm obviously sensitive about this because I've got college-age kids. I found it surprising, and like I said, I think a lot of other families would find it surprising as well, because I think people think of income as income. And, true, maybe you shouldn't, but to the extent that we can avoid having situations that are traps for the unwary, I'd like to do that.
Okay, we're happy to bring back an analysis of this issues to further explore it.
Okay, all right, thank you. Any other advice letters that commissioners wanted to talk about? All right, thank you both very much. Moving on, is there any public comment on the advice letters before we move on? Seeing none. All right, executive staff reports. Let's go ahead and start with the administrative report. Executive Director Jones, what items do you have for us today?
Thank you, Mr. Chair. I usually have the luxury of batting cleanup if something is left on the table, but I'll go ahead. There were two IP meetings that were held in this past month. Dave mentioned one of them. The other one was with respect to technical changes, and we did get a smattering of comments for each of those, so we'll continue to work in that regard. Big shout out to the Education Division that completed the manuals and have posted them up on the website for public comment, which is due, I believe, November 13th is the deadline for public comment, but that is a Herculean effort that the commission doesn't really get to see first on, but they really put a lot of work into that. So we're happy that at least this phase is done. In response to your question about the budget note, AB 571 calls for just shy of $1 million budget note with 4 positions coming to us. We've already submitted the BCP. I should say Larissa has. I just signed it, but that has already gone in. We're looking for the budget come the end of this fiscal year, so end of June. We're hoping to be able to start staffing up for that. A reminder that the November meeting is going to be a 2-day affair with the Enforcement Palooza on one of the days, and we'll also have the small gathering to celebrate the 45th anniversary of the PRA on Friday morning before that session. And that's all that I have by way of update, but I'm happy to answer any questions that the commission might have.
Any questions for Executive Director Jones?
Are we noticing that as a palooza? Because
There is a special regulation with regard to paloozas that we're going to follow to a T and make sure that it's.
we can take action during paloozas.
That's correct.
All right. Thank you, Executive Director Jones, unless anybody else has. All right. Go ahead and go to the Legal Division report, since you already here, Mr. Bainbridge. Anything from the Legal Division report that you'd like to bring to our attention?
You're going backwards, huh? It's tricky.
I am. I like to mix it up sometimes.
Keep us on our toes. Well, since you went backwards, my thunder got stolen. I wanted to thank the Education Division for all their hard work on the campaign manuals, as well as the lobbying manual, and also a revised Form 700, which is all up on our website for the public to review. There's a 30-day comment period on all those items, although that period runs into the comment period for items that will be on the agenda for the commission. So actually, they have until the next commission meeting. If you have any comments about the manuals that are up on the website, we'll be taking those. They will come to the commission in November for approval. If you want to look for them on our website, it's under the About FPPC tab, under Hearings, Meetings, and Workshops, and then under Interested Persons. And so just thanks to Suki and Deborah and Alex and Allie and Alana and Katie for all their hard work on these things. They're quite a task, and they really had to push it to get them on before the election, which we are starting to gear up for that with the March primary this year. You'll notice in our Legal Division report that from the pending litigation, the Howard Jarvis Taxpayers Association case is no longer there. That's because the time for appeal has run and no appeal was filed. So essentially that item is concluded. There may be some minor procedural stuff that still needs to go on, but from our perspective, that means things are status quo because we've been under a court order for some time prohibiting us from enforcing the law that was passed that was declared void. So nothing new other than that matter is concluded. And then I just wanted to point out that this isn't in the report, and maybe it'll be in next month's, but Karen Harrison, one of the attorneys in the Legal Division, has done a couple presentations to local attorneys, DAs, and then city attorneys in Contra Costa County and in San Luis Obispo County regarding Government Code 1090, both the basics of it and then also the advice process we have here for 1090 questions. And she says they were well received, and I believe her. So I just wanted to give her some credit and let people know that we're out informing some of the other government attorneys about how that complicated area of the law works and what kind of services we provide in terms of it. That's all I got.
All right. Thank you. Any other commissioner comments on the Legal Division report?
I have a question. And I guess this is for our outreach and educational activities just per se, but I'm just wondering, as I hear you say that, Dave, the presentation that Karen gave to Contra Costa County, is there any sense that because of where the commission offices are, that one part of the state is getting appreciably more or less outreach activity, in-person outreach activity than any other part?
I haven't heard that. Our Education Division routinely travels to different parts of the state. They were just in Fresno, I think, this week. They were in San Diego or are going pretty soon. So I haven't heard that's an issue. I mean, I think obviously there's some outer reaches of the state that are harder to get to and are less populated. But our goal is to try to get everywhere in the state. Obviously, an hour-and-a-half drive is a lot easier for us to go do a training. It was just like an hour-long luncheon training, and we may not be able to go to Southern California and fly down there for that sort of training, but for the more comprehensive, longer trainings, we do travel all over the state for.
All right. Thank you very much. And last but not least, Chief of Enforcement West. Do any commissioners have any questions on the Enforcement Division's report this month?
I do. Just a quick one, I think. And I've lost my page, but Ms. West, here it is, the table where your staff lays out, I think it's on page 3, the complaints received, et cetera. And I'm not asking for make work. My question is there some existing readily transmittable breakout per election cycle, not just calendar year? I'm just wondering.
Not really, Galena West Chief of Enforcement, because the calendar year just generally includes both the primary and the general, and that's when the complaints you can see ramp up drastically, 2016, 2018, and then referrals tend to drop. Unfortunately, don't drop enough, and then in the off years, there's a lot of cleanup referrals come in. It's more calendar year somewhat accurately represents what's going on.
What accounts, do you think, for the significant uptick in actual referrals received? Is it the modality by which people can submit now? Is it more easy?
Yeah, I do.
Is it more easy?
It's more easy.
More easy? Oh.
No, I do think it's easier to make a referral now because of the electronic system. And also as the PRAs in the news more and more of the filing officers are checking their records and making sure that they stay up on this. And then also the third thing that goes into that is our pre-election efforts, where we reach out to all of the filing officers that in every county and then every city over 100,000 having an election. And so with those proactive efforts, we get more referrals because we say, hey, listen, we have this program. If you participate, we can get people filing 100% of the time before the election.
There's a bit of a widening, I don't want to say chasm, but distinction between, I don't want to say yield, but the percentage of complaints that we receive and the percentage of cases opened as a subset of the numbers of complaints received appears to be going down. And I'm just wondering, is it because the more easily transmittable complaints are shorter and more, maybe less substantive?
I do think with the online system, we do get a small percentage of complaints that are just, this guy's a slime ball, you should look into him. And so, those generally don't give us enough to follow up with. And so that is the case for those. And then the ones that get open, as the act gets more complicated, tend to take a little longer. And so it's kind of this, there's a lot of these, and also you have duplicates where someone submits it twice. And so those account for a lot of the ones that we don't open.
Just wondering. Thank you very much.
Actually, I had a question. On page 3, I think you were on page 3 too, referrals received. We have a significant spike beginning in 2017.
Mm-hmm.
What accounts for that?
I really think it's the publicity. I think that filing officers are taking over the job as filing officer, and they're going back through their records because a lot of the referrals we get, they're not necessarily the most current. So like, for instance, San Diego just went through all of their old records and they gave us referrals, some outside of statute, to where we're like, hey, you got to get them in the statute. Yeah. But and so I think a lot of people are taking on these jobs and taking them seriously and then deciding to clean house. And when they do that, our number of referrals go up.
All right. And so is that something that we proactively sought to educate filing officers with respect to? And that's what we're seeing.
Education does a really great efforts to work with filing officers to help educate them. And they also, there's a clerks association that does great outreach for their own members. And for enforcement, we definitely try to educate clerks and filing officers. And as we work with them election after election, they get more educated and become more aware of what all the filing requirements are, and then make informed referrals.
All right. Well, I think that's a noteworthy connection between our efforts with respect to education and the work that's being done in legal and education, what enforcement is able to do as well. So any other comments on the Enforcement Division report? No. All right. Hearing none, thank you. All right, at this time, I'd like unless the commissioners have other business at this point, I think we would reconvene in closed session on item 20 to conclude our deliberations on that matter. So we'll be back.
Could I just ask a quick question, Mr. Chair, with your indulgence? The 45th anniversary, what is happening, and is this something that should be on the website? I mean, what are we doing? What?
I can give you the contours of it right now. I thought it would be appropriate to have this commission be able to celebrate internally what the legislature celebrated for us earlier on this year. My anticipation is that will be no larger than this room. We have reached out to every former commissioner of the agency to invite them if they want to come. We haven't gotten any RSVPs back, but that's mainly because we sent a save the date email thus far. But we do plan on reaching out to them and seeing if we can get a small gathering here just to show our appreciation for the 45 years of this commission. We will also be hanging up an honorary plaque to commemorate the anniversary.
Thank you.
Thank you. At this point, we'll adjourn into closed session. All right, reconvening in open public session. We've concluded our closed session deliberations on item 20. First, as a matter of housekeeping, as part of the public comments on item 20, we received a document that was styled as an amicus brief. For clarity's sake, we are considering that in the same way we are considering other public comments, which is as statements in general in nature and not specific to this particular item. With respect to item 20, the commission has decided to modify the decision in two ways. First, with respect to the proposed penalties, with respect to count 1, the commission is reducing the penalty from $2,500 to $1,500. And that is in light of the fact that that violation occurred the violation occurred, but Ms. Shelley had proactively sought advice from the commission. The remaining counts, however, we are accepting the administrative law judge's recommendation of $2,500. All of those counts occurred after Ms. Shelley had reached out to commission staff and had received information about filing requirements. We are also modifying the decision in some technical ways. Those are reflected in the materials that are on the agenda. We will also be publishing a modified decision within the next week or so, I'm told from legal staff. So at this point, that is what we've decided to do on item 20. And thank you to everybody who participated. Moving on to item 21, commissioner comments on proposed future agenda items. Do we have any commissioner comments? Well, Commissioner Hatch, why don't you go ahead and start?
All right, okay. I hate doing, in some ways I hate doing this because I used to quietly mutter to myself about legislators who introduce bills on Monday that they read about in the LA Times on Sunday, but I guess I'm guilty of that today. In the Los Angeles Times, there was an article about nearly $800,000 spent by the California Democratic Party, either in a combination of lawyers' fees and settlement payments for even beyond sexual harassment. I think some of the charges were sexual assault. And in light of the fact that we'd made an effort legislatively last year, or this year that's closing, on elected officials and candidate accounts and the use of, legal defense funds, I would like to, at a future date, have a discussion about what, if anything, in regulatory authority that the commission may have with respect to the party's use of money for this purpose, and if not, what legislative remedies might be allowed to pursue in the coming year on that subject matter. If you don't mind, I'd like to defer to Allison while I try and figure out what my handwriting means here.
All right, Commissioner Hayward.
Yeah, I would like to, and I think maybe this is an appropriate thing to talk about during our enforcement meeting next month, but, if it's not, let me know. So I looked with interest at the matter that's just come to light in the news regarding the foreign agents laundering of foreign money into domestic campaigns and it turns out maybe bribes and some other things as well. The model of that having been discovered by a good government group who was looking at big contributions to certain super PACs and other committees. And they found a name of an LLC that they'd never heard of before, and they started digging. Now, because California is a jurisdiction that allows corporate contributions, it is, in fact, I think, an issue to think about how many contribution sources are actually shells for other money that is not permissible. I'm trying to think in my head if there's a practical way to do this. I don't know if we could find somebody who could program something that would scrape like the stuff filed with the Secretary of State's office to look for, various corporate forms and contributions of over a certain amount that we think sets up red flags. And if then there's a practical way to go back and look at those corporate filings and see, as in the case of the scandal just recently unfolding, the LLC was formed like a month before the money was given. So it was pretty clear that it got money from something else, not its own continuing business. And that, I think, would be the kind of shell or straw donor type situation we'd be looking at. So this is something I think is timely. And now that it's made the news, I'm certain there are other bad actors who are thinking, hey, maybe I could get away with that. And so I'd like to look at that as a potential enforcement priority.
Commissioner Cardenas, do you have anything? Commissioner Hatch?
If I can't figure it out, I'll have to wait till next month.
Well, I have a comment, so you can continue to think about it if you want. I just wanted to let folks know that I had recently attended a meeting with the Political Reform Division of the Secretary of State's office. I think, as everybody knows, they are attempting to create and roll out in 2021 an updated filing system, electronic filing system for us. We call it the CARS system. As part of that, they will be doing some
We're
external
sorry. Your
testing.
conference is ending now. Please hang up.
My comment is that for other commissioners, that in the future, I would anticipate probably towards the end of next year, we may need to consider some regulatory changes to help folks, because my sense is that the system may need additional refinement, at least as it's currently structured, after February of 2021. So filers may need some assistance from us, making sure that they're able to comply using the new system. So something to think about. One final shot. Do you have anything?
I can't think. Sorry.
All right. Do I have a motion to adjourn then?
So moved.
Second.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Chair Matich?
Yes.
Motion passes.
When it's gone, it's gone.